All right, Mr. Simmons, you're up.
Hi, Judge Binkley.
Fine, sir. How are you?
Happy to be alive.
Yes. Amen to that.
So I'm going to do the first motion. I'm going to separate them. Is that okay? The motion to stay first and then argue the other one last. Is that okay?
Sure.
Okay, because I didn't want to merge them and be all over the place.
I don't know why I'm not hearing it very well.
This one may not unplug because it was also in the crackle sound.
Okay, so we have to turn it off.
Opposite is replacement.
Okay.
Want me to talk a little louder?
Pull that microphone up. Just yeah. So it'll just, you're a tall guy, so just point it to your mouth.
Oh, I see what you're saying. What about now? For some reason, I have a little bass voice going on today from my allergies, so please forgive me. So the first motion I'm going to address is the motion to stay the proceedings pending the appellate review. The motion to stay.
That's the one you're withdrawing, is that correct?
Well, I was going to withdraw it, but then I realized I needed to address this one.
All right.
If that's okay.
Mr. Simmons, did you want this recorded?
Yes, I did ask.
He said he wanted the recording turned off.
We're recording. It's going, right?
Yes.
Okay. So on May 22nd, 2025, remanding this case to this court, the appeals did mandated
To do what?
to mandate.
What to do what? What does the mandate tell me to do?
Right now, I couldn't tell you verbatim what the mandate would say to do, but it is to, as it looked.
Here's what it says. The mandate says, therefore, we are requiring you, the Davis County Circuit Court, that's me, that you proceed with the execution of this judgment of the Court of Appeals. So that means the judgment is that the motion for summary judgment filed by defense was granted and your case was dismissed. So there's nothing further for me to do.
So in that sense, you got the ruling is there's no need of doing the other motion as well?
Yeah, there's other motions that you filed, and they're well, anyway, you go ahead and make your argument.
Well, I mean, if the court has already made its decision from the...
Well, you've got the recording going, so you're probably going to appeal whatever I do, so.
Yes, sir. So with that being said, from the mandate from the Court of Appeals, when they sent the mandate, I had filed 3 motions prior to the court. And the court sent the mandate down while my motions for substitution, motion for 25.01, also motion for sanctions. Because in this case, the court was not aware that the defendant had died in the process. So therefore, the record would be procedurally not fully adjudicated.
What further do I need to do?
What we need to do is, what I'm asking this court to do is simply substitute Mrs. Islam as the executor, which she was the...
Why?
Why? Because he died before the judgment came in. So the rule says if a party dies and before it is extinguished, the court should have known. So I will say this, that the defendants knew that their client...
The court should have known. What does that mean? The court should have known.
Okay, I'm going to go back. So, and please forgive me for my vernacular, so I'm going to try to say this a little slower. So it is the duty under Rule 25.01 that when a defendant knows that their client is dead, they're to inform the court and inform the plaintiff or the appellant in this process. It was in the appeals court. Dr. Islam died August the 12th, 2024. We argued, and let me proceed back, we argued July 9th, and then we went ahead and then he passed away.
July 9th of
2024.
And argued where?
In the Court of Appeals, and thank you for correcting me on that. So that's important. And so we were in the Court of Appeals. So the law says that when a party dies, that we're supposed to be informed. There is no way that the defendants did not know that their client was not dead or deceased.
How do we know that?
I can give one rule that will guarantee it, and one only. And that's when, on December the 3rd, when the ruling came in of 2024, from the Court of Appeals, he died. the ruling came in, so they had to inform their client. The law says duty of candor, by that the attorneys had a duty to inform their client of the win that they won in the Court of Appeals. They had to speak to them at some point. Whether it was by email, telephone, mail, something had to be done, because one cannot say as counsel and say, well, I don't have to tell my client. That is not true. So that's one instance that I know that they should have told. At that point, they should have called the Court of Appeals and let them know, say, my client has been deceased, and you made a ruling. At the point the law says, in the cases that I have looked at, and I've cited them in my briefs, in this motions, they were supposed to go back if they found out when he died on August the 12th, 2024, and I say for a month, they had plenty enough time to call the court and inform the court that my client has passed away. At that point, it says substitution would have been made. It would have been an offer, and all the proceedings would have stopped. This case is not here to relitigate the merits, but it's a procedural error that has happened here, which caused injustices.
What is the injustice?
The injustice is that they did not even tell the court that he died.
What's the injustice?
The injustice is the harm, and I have it right here, Your Honor. The injustice is procedural harm, that's an injustice. Number 2 is substantive harm, that's an injustice. And due process. And let's go to our due process. The harm. I said I was denied the notice of the event of the death that materially affected my rights and the ability to respond meaningfully. That's out of the Tennessee Supreme Court. It says when they do not, it has been a denial. And how did they not know that he was dead? That's why I filed a motion for the substantive record to be proved. When did they know? How did they know? And why did they keep it? The law is very clear, even though the court has already made up its decision. But the law is clear that the attorneys committed fraud and misrepresentation. There's no way that they didn't know their client wasn't dead. And
what's the fraud and what's the misrepresentation?
Misrepresentation and fraud is that if a party dies while we're in the proceeding of the court, while we're proceeding on the case.
We don't have any proceeding pending in this court.
Well, not this court, but I'm saying when we were in, let me be clear, when I was in the appeals court.
Well, if you've got an argument about the Court of Appeals not doing what they're supposed to do, that's for them to be addressed, not me.
Well, the Court of Appeals, it seems from the mandate, if I can remember, that the jurisdiction lies back within this court because of the motion for summary judgment.
With the execution of the judgment. The judgment from this court is your case is dismissed.
Yes, but it's not dismissed in the sense that it's fully adjudicated.
What has to be adjudicated?
Well,
what's left?
What's left is that we go back and substitute Mrs. Islam as the party.
For what reason?
For the reason is that she was supposed to be the party when we were in the appeals court. We're not even supposed to be in this court, technically, because now we're dealing with a jurisdictional issue. The issue is that the death happened in the appellate level.
Well, that's where you need to address your complaint.
Well, I addressed it, and then the court sent it down and sent a letter and said that it was with this court that had the jurisdiction over their jurisdiction.
But
that's not correct.
there is a motion still in the Court of Appeals that has not yet been ruled on. Plaintiff's motion for relief from the mandate and or for a rehearing. And he filed a response to reply to my response on Thursday or Friday.
It was
in
Friday.
The court.
In the Court of Appeals.
Court of Appeals. Okay. See, I'm out of that loop. So if you've got something to address to the Court of Appeals, that's where you need to address your issues, not me.
Well, it seems to me, Your Honor, that today that I'm here more so for the court to address Mrs. Islam being substituted because this court has the jurisdiction over that. If that's the case, I can leave the motion to stay and go and wait till they rule up from the Court of Appeals and then deal with just the motion for to add Mrs. Islam. But I will say this to the court. It is a fact that when a party dies, the attorneys who represent them, a candor of duty, under all of the statutes that says for an attorney not to be sanctioned must be forthcoming. And in forthcoming, they have plenty of time in that appeals court.
Okay, now hold on. That's if something is still pending in the trial court. There's nothing about your case that's pending in this court.
I would argue with the court prior to this, everything coming together and it under the finalization. Yes, it looks final, but on a procedural basis in the Court of Appeals, it is not final because what should have happened, because the record is now incomplete, even before this court.
What record?
The
What's incomplete?
The record that was sent down from the Court of Appeals is incomplete because they're under the belief that this case was procedurally not flawed, but it is flawed. It's flawed because of the death of a, you can't have a ruling on a dead man, on a dead person, on a deceased person.
That's if a matter is still pending in that case. We have nothing pending in that case. Your case is dismissed.
Right, as it says. That's why I'm here today. And I understand.
What's why you're here today?
To say that under that mandate, or what was sent back down to this court, that the appeals court now, or this court, they stated it, I think in the letter, that this court has the jurisdiction to overturn the jurisdiction because the merits. I'm not relitigating the merits, but this court has authority.
Well, if you're not relitigating the merits, then there's nothing to relitigate.
It's the merits, and let me just hold. May I get my paperwork so I can say this correctly? Because I didn't know it was going to go this route, but I can get it. Okay, so may I read this so that I can get it correct and I won't make a mistake in my language?
Sure.
Okay. The defendant asserts that the appellate court issued a final mandate and subsequent appellate remedies are exhausted. The case is finalized, is what it believes. However, I argue that the final mandate does not immunize the record from post-judgment relief when the underlying record is substantially deficient.
Where is it deficient?
Can I finish? I'll read it and then it'll tell me. So the court, I won't be all over the place as a pro se litigant. As established in the aforementioned authorities, a judgment rendered on an incomplete record, particularly one failing to address proper substitution of a deceased party, can be subject to equitable relief to ensure that that justice is fully served. So when he died at the appellate level, and they mandated this back, that is one of the reasons where we can state for sure there was a deficiency and a procedural error. We know for sure that when they gave the verdict, they should have known that he was dead. They had ample time to tell the court. So for us to be in this courtroom today and said, okay, well, this is what they said, this is what the appeals court said. Yeah, they said, they wrote that. They wrote it very clearly, but also it was flawed on a procedural error. And that flaw had a bearing on the final decision. The final decision meaning that they would not have given a final decision. They would have done a Rule 25.01 and then a Rule 19, and then they would have given 90 days for substitution. But at that point, the attorneys, the defendant, counsel, never told the appeals court, never told the Tennessee Supreme Court.
You told me that earlier. I've got that.
Okay. So further proceeding on the corrected record, it says the record, with the record corrected, the trial court may reevaluate any motions that is in light of the correct party before the court. And so I would say to you, Judge Binkley, the procedural error correction could in turn result in a different outcome than the previous judgment if and only if the material omission, namely the failure to substitute the proper party upon the defendant's death, would have affected the merits. Then based on the record, the procedural timeline in this case, in which I met the timeline, and it's very interesting if I could just point this out. How is it that I, the plaintiff, found out that the defendant was dead? And I notified the court and this court. There is no way that the defendants here and this court can say, okay, you're fully adjudicated. This case is over with. If it's a procedural flaw, and then I'm going to cite the case from the Tennessee Supreme Court that just came out in 2023 that talks about that if it's a procedural flaw, such as a death, the court has the authority to remand the case or to reopen the case, Rule 60.02, this court has some authority because what you have before you is incomplete. Now, I know the court is of the assumption that everything is fully adjudicated. Well, it's not. Let me get my points on the adjudication. And I'll say this. The trial court's summary judgment was affirmed by the Court of Appeals on December the 3rd. And the application for permission to appeal to the Supreme Court, Tennessee Supreme Court, on April 17th. Was denied, the application. But once the appellate court affirms the judgment and the permission to appeal is denied, the judgment is considered, it says final, but under the Tennessee appellate rules, generally cannot file a further direct, I can't file a direct appeal. The judgment is sent it back to this court. So in this court, then it says what this court has the authority to do is that to challenge the judgment if it is defective. This judgment is defective because of a deceased defendant. It's defective, which causes...
What difference does it make if your case is dismissed?
It makes a difference because that means that the order, the judgment is not a final judgment. It's not final. It is only a judgment that was sent down, and then that's where it comes into place that if the judgment is not final, then Ms. Islam should have been substituted before the Court of Appeals rendered the verdict in December the 3rd, 2024.
So you're back to the argument about the Court of Appeals having done something right. That has nothing to do with me.
So let's just ask the court, have you already made your decision? So this is a waste of time because from what I've understood, the application for substitution in these cases, that when it's remanded back to this court, and especially with the grievance of what has happened here, that a dead defendant, this court can't even make it final because he's deceased. We cannot make a final judgment on a deceased person. He has been dead. Now 9 months, or more, 9.5 months. So the order that the court is going to give is appealable back to the appeals court because the appeals court is going to say it is the duty of candor for them to have been told, and they do not take the words that they use, take fund of attorneys not informing them or any party not informing them if a person is deceased at all. So the judgment rendered...
Now, where are you finding that language? Is that in an appeals opinion?
Yes, sir. Let me give it to you. Thank you for your patience on that. I thought I had these memorized. I didn't know we were going to go into this. And can I address why I'm looking for this? It's called, I want to talk about the mootness that was filed by the defendants. In this case, it's moot. It's already adjudicated, which the court is believing that it's adjudicated. If I could just get this even for the record.
I thought we were going to stick with the motion to stay first. Because, I mean, if you grant that motion, we're done. Right? I mean, there's something pending in the Court of Appeals. He's filed something on Friday in the Court of Appeals. He's asking this court to not do anything pending the Court of Appeals decision.
That's fine with me. I mean, I did do that.
Okay. And you believe that is the right posture?
I opposed his motion because I feel like this court has jurisdiction. However, I'm having to fight this on two fronts. I'd rather fight it on just one. And if he wants this court to stay any further action, let the Court of Appeals rule in his pending motion, which he filed a response on Friday, then I think he could, depending on what happens there, he could come back to this court.
What is pending there? So see, I'm out of that loop. When you all file things in the Court of Appeals, I have no clue what you're doing.
It's a motion for relief from the mandate and or for a rehearing. Happy to pass it
Okay. All right. Well, is that right? Is that
Yes,
what your motion is?
Yes, sir. That is correct.
Okay.
because I filed that the mandate that at
Well,
the,
we'll grant your motion to stay until the Court of Appeals rules on your motion.
yes, sir.
All right?
Judge Binkley, thank you for being so nice to me today, and I wasn't nervous for the first time in front of you, so I really appreciate you for that.
Sure.
I get nervous really bad around you, and I don't speak well, but thank you for your patience and grace and mercy.
You're doing fine. All right, so we've got three other motions that you filed, but so we'll put a stay on everything until the appellate court makes a ruling on your motion to change the mandate. Is that what the motion is? See,
It's a motion.
why don't we let's put it on the screen.
I don't have
You don't have all that, do you?
No, I didn't bring that with, I didn't know we were going to argue that, and I didn't know I had three motions in here, I had two.
Just, it was confusing. He filed two motions which were set to be heard today, a motion for stay and a motion to lift the protective order. And in the interim, he filed 4 additional motions,
Right.
which when I was headed out of town and said I can't be ready for those today. So you had 2 motions, in my understanding, on your docket today.
And this is a motion to say that we're going to be here anyway.
And in this particular motion we're looking at, he filed essentially a reply on Friday with the Court of Appeals.
And actually,
A reply to your response.
Right.
What was your response?
So many motions. I'm sure it's similar. I think my response was that mandate had issued, and that by denying the application for permission to appeal, mandate, I used their language, had immediately issued, and the court had said so in its order, and therefore it was remanded to you. All right, so, but it's just one or the other. I mean, and we've got to have some relief at one place. We have to have finality, I think, at the Court of Appeals on this motion.
I think that's right. Of course, I was unaware of any filing in the Court of Appeals. See, Court of Appeals, I don't get any of that. I don't get any notice of that. If you're still in the Court of Appeals, I don't get a notice of that. So it's been helpful to know that.
well, Your Honor, this is what I thought. When they said the record had been sent back to you, I was under the impression.
There's no record been sent back.
Well, that's what I read in my letter that I got from the Court of Appeals. I got 2 letters that said that the record was sent back to the trial court. And
Okay, so,
that was
but that's just sent back because they don't want to keep it. They're sent back here because it's done. They're done in the Court of Appeals. But now I'm understanding you're not done in the Court of Appeals. You've got something pending there that they need to rule on.
Well, let me just, if I could, for clarification, when you say done, I had already filed the motions prior to the court sending that letter to the mandate. So,
And when you say letter, it's really...
I mean my motions.
Well, listen. Okay.
So the motions were filed. And so if they're sending everything back to this court, then my motions that were already in the Court of Appeals would, I'm thinking, as you said, would be filed back into this court. So I don't know the procedural to the...
Well, if you... All right, just stop just a minute. You've got something pending in the Court of Appeals. They need to rule on that before I rule on anything else.
Okay, and last, if I may, the Court of Appeals instructed us not to file anything else into the Court of Appeals. That's one of my letters. So my motion was already there.
Do you have that?
Huh?
You have that?
No, sir. I didn't bring their letters with me today.
Okay.
But at that point, then Mrs. Lohmeyer, the defendants, they filed a response to when it said not to.
They had only ruled on 3 of his motions and not this one,
Yes.
so we had to file this one.
Yeah, I
We
understand.
couldn't let it go unanswered.
Well, I was confused because if someone tells me not to file anything else,
Well, you filed something anyway on Friday. Didn't confuse you too
but
bad.
that was a response to your reply, a reply to your response, however that goes. So I had to file. And so,
Well, it's like Ms. Lawmer says she had to file a response to your motion. Then it's the same difference. You filed a reply to her response, even though the Court of Appeals said don't file anything else. I mean,
but let me be clear. I filed 4 motions at the same time. They
Where?
only addressed 3
in the Court of Appeals. Right?
in the Court of Appeals. Only 3 were addressed. The other one was not addressed.
I
So
understand.
therefore, that's why.
I understand. That's why they need to rule before I go any further.
Well, Thank you, Judge Binkley. I really appreciate that. So I understand the protocol now, so it makes sense. But I just wanted for clarification. I did file 4 motions at one time. They said 3 of them back, and so this one was pending.
Well, they didn't send 3 of them back, did they?
No, they just said it was 3 that they were not going to address.
Right.
But the motion to stay, they would, I guess that's what they're going to address. So that's my next step, is waiting on them to say whatever
Well,
they're going to
it's
take.
your ruling. Just-
Give me a ruling.
This is your ruling on your final pending motion. Right?
I guess that's what it's going to be, and then we'll be back here.
Well, if they've told you not to file anything else, I think that's going to be it, sounds like.
Well, then, if they
In the
told,
Court of Appeals, it's, just have a seat.
thank you so much.
Okay. You had anything else? Ms.
I would
Lane?
just, for the record, hope and ask that the motions that he ultimately will refile be heard on a regular docket or a regular day, just trying to juggle special hearings, and the court as well, I appreciate, is difficult, so.
So we'll hear it on a motion docket.
Okay, if you don't mind, Judge Binkley, the reason why I asked for an expedited hearing is because there is a
Well, I gave you one, so
Well, I didn't know this was an expedited because
this is not a regular motion day. You know,
Oh, I know.
Fridays are motion days.
Yeah, because I filed this on the 5th, so I thought it would be sooner because the reason is, under Rule 25.01, I only have 90 days to inform Mrs. Islam or the deceased party to come in. So if I'm going to go, I'm getting ready to go past the 90 days. That's why I asked for, as I replied in my motion, because the 90 days, I didn't want to go exclude the 90 days, and then I would be dealing with the statute of limitations.
Well, you better address that to the Court of Appeals then. That's what you really should do. And here I am giving you legal advice, which I'm not supposed to do.
Well, thank you, Judge Binkley. I really do appreciate that.
All right? So would you prepare the order, please?
Yes.
So stay is granted, and then we'll wait until the Court of Appeals rules on his final motion that's pending there
All right,
before we hear anything further.
okay.
Isn't that what?
Yes, that's my understanding, yes.
Okay. All right.
I think procedurally,
That's the right way to do it.
I think so.
Okay. Thank you. All right. Y'all have a good day.
Thank you.
Thank you for hearing me today.
Thank you. Is there anything I can do for you all in the back? Okay.